Hello, and thank you very much for coming to listen to me today. It's an honour to be connected to the other side of the world, and particularly luxurious to be talking about this from the comfort of my own home. I know that New Zealand has had some similar discussions about sex and gender to those in the UK, and I'm going to talk about the law over here. I specialise in human rights, in particular in the field of migration, where sex and gender have a particular niche. And I know that New Zealand prides itself on respect for human rights, whether that is within the broad scope of the common law or the domestic law of your Human Rights Act of 1993. I start with this fundamental premise. All humans have rights by virtue of being born human. That much we all agree on. Women's rights are human rights. Trans rights are human rights. All of us are human. Many human rights are what we call qualified rights. The European Convention on Human Rights provides for only 3 absolute rights. Those are the right to life, freedom from torture, and right to a fair trial. The rest are qualified, which means that an individual has the right, but the state may interfere with that right where it is necessary, and we often refer to that as a proportionate means of achieving a legitimate aim. So what is a qualified right? Let's take an easy example. You have the right to liberty, unless the state deprives you of liberty due to a custodial sentence. You are free from slavery, but if you have to do unpaid work as part of a community sentence, that is not a breach of human rights. A balance must be found between the rights of the individual and the interest of wider society. And in perhaps the majority of cases, there will be no clash. But where there is, the balance must be established. Now, what makes it far harder is where the clash is not between the rights of the individual and the interests of society, but between competing rights of individuals. And that is where this discussion is pitched. I'll just mention Article 8 of the European Convention on Human Rights here, because this is where so much of the focus is in the UK and in Europe. Article 8 is the right to private and family life. It's broad. It's not just the right to have a family, it's the right to one's own identity and autonomy. It can include sexual orientation, gender identity, nationality and national identity. It's been called a sphere within which one can freely pursue the development and fulfilment of personality, a right to personal development, to establish and develop relationships with other human beings, your desired appearance, your traditional ethnic identity. Summing that up, I'd say it's your sense of self. So obviously, both the right to establish a gender identity, also the right to reject any gender, are important here. In a human rights framework, what are women's rights? In the UK under the Equality Act 2010, and I think also under New Zealand law in the Human Rights Act of 1993, sex is a protected characteristic. Some women do need single-sex space, in particular circumstances. And I pause here to note that in the US State Department report on country human rights practices for New Zealand, it reported that 1 in 4 women have suffered intimate partner or sexual violence. Now, not all of those survivors will need specialist single-sex support, but many will. At the moment, here in the UK, there are exemptions in the Equality Act to protect single-sex services, where a service provider can offer a single-sex service in certain circumstances. And those include 1, where women have experienced trauma, such as women's refuges, rape crisis centres, domestic violence services, and so on. 2, where women need safety, privacy, and dignity, such as in women's prisons. And it's worth noting here that Article 8 of the UN Standard Minimum Rules for the Treatment of Prisoners is clear that women must have separate space in prisons. 3, where women are physically at a disadvantage, such as in women's sports. And 4, where single-sex provision exists to repair the historic sidelining of women and marginalisation of girls resulting in unfairness, such as all women shortlists. Now, so far, much of that might seem obvious. But women have rights under Article 8 to privacy, including, I would say, not having to explain themselves to a service provider if they need single-sex services. For example, you shouldn't need to disclose a history of sexual violence. You've also got Article 9, religious beliefs. Some women will need single-sex services due to their religious beliefs. Then we look towards trans rights. Now, at the moment in the UK and beyond, that is protected by gender reassignment, not gender identity. Reassignment is measurable, while identity is not. Now, the right to identity is absolutely important. Nobody should ever face discrimination for wanting to project their gender in opposition to gender norms. Feminists have, after all, been doing that for over a century. We also have more tangible rights to education, employment, healthcare, and freedom from violence. I would say self-identification within that broader framework is a bit of a red herring. Of course, everyone has the right to identify themselves however they like. But where someone wants to renegotiate their legal relationship with the state, that right does have to be balanced against the public interest, just as it does to get citizenship or disability benefits or to be recognised as a refugee. None of those things can be done simply through self-determination. Interference must be minimal. That isn't to say there can be no interference, particularly given that the case law establishing all of this focuses on dysphoria. And so the balance that has been established is done on an assessment of the relatively small number of those with dysphoria who wish to transition from male to female or female to male. And in the main case, I would call it of Goodwin, it was expressly said that the balance tipped towards the individual because there were so few people to whom this would apply. There's nothing in that broader case law there about gender as a broader concept of self-perception, including, of course, the large number of those who identify as non-binary. Now, as I noted above, gender identity falls within Article 8 in a way that other identities do. It's the individual's right to a sense of self. Other identities already established include the right to an ethnic identity, a religious identity, even a political identity, and that identity is separate to the practices or expressions associated with them. Now, something I think has been missing from this debate is that state registrations of such identities has historically not been a positive for human rights. It's one thing someone, perhaps with a medical condition of dysphoria, applying to renegotiate their relationship with the state, where application and state involvement is a necessary evil to change a state-issued document. It's quite another thing for the state to build and hold a giant database of the gender non-conforming, incorporating the much larger number of those across the gender spectrum and the multiplicity of non-binary identities. We don't have to look very far to see how such a database could be misused. That's possibly a topic for a separate paper. So we're looking at three groups, all of which have crossover with one another, all of which deserve protection as discrete groups: women, those who have or are undergoing gender reassignment, and those with any other transgender identity, including within a non-binary identity. So how do we find a route through this which allows all groups the minimum possible interference with their rights? We need clear delineation. Women have a human right to privacy and dignity in single-sex spaces, particularly in the circumstances I outlined above. Trans people have a human right to privacy and dignity, including in identity. My proposed solution is this: preservation of single-sex services, establishment of single-gender services where single-sex is not needed, and everybody to be properly supported to present themselves however they wish. It cannot be beyond the wit of the legislature to protect the rights of trans people and also ensure that the rights of women and girls are maintained. Thank you.